okayfm 101.7.
Yanko yanim na fe yane Yera Godwin Edudzi Tamakloe Esquire. We're private legal practitioner aid ma former President Mahama entwetwe enkomo. Na no me mo ache no pay.
Kwame anopa me joso na me chia okayfm me chia fo nyina bra kwame.
Na boko de.
Obwade adaro ma bra kwame.
Enwa na me krata bi se twa owie mu. Na krata na etwa owie mu nyina ne se mode makoye appeal ewo eye high court ruling na ehwo asem to say eye Assin of issue no.
Yo bra kwame the akoba no say enra obwade eye yadom yen a lawyer for your call the registry of the high court ewo Cape Coast. So to say court of appeal be ACT ewo Cape Coast. Inti enra no yeko ho eko file the notice of appeal na yewie na national chairman any ye MP na ene ko sema onye MP bio no any some other national executives Sami Jemfi Joshua Kambanum ene ke kan ho Broja Jemfi no ko constituency ede no culture ahemfo a ewo breku ene ke kan ho nti enra de ekosi ya no brakwa
Na mami musade sabre kudie no na eyeden something of a plant eya na say ende ebetu omu keke
ende ebetu omu keke so no a ho no ofi nti enra no ekoba say ye file appeal no wie no one who say Cape Coast nso ne Assin no de nya de wa bia nti ye file notice of appeal no wie no na ekoba mu so okay we dey ya do Cape Coast dey yenfa kromo na yenhwe dey ekoko eba because sebi encrofo ato abama ama we winning with over 2,700 votes difference na Assin say aba at least on members on metie bibi kakra ayeden efi wano sebio how you feel wondering what is the way forward and then get home intina say yanko pm na sebi emra team no edu kromo ho no and the momomi ene ho ka ho na nkrofo no edibe asia team no and what dey na krabehwe bra kwa
mami musa edie na mu hu no judgment ni mu a ma mo ye said there be ade we dey maybe the judge erred in his ruling mo de eko appeal
you see bra kwa me some fan your man you be entuga I would say in the normal way of our trial system no me the friend of pleadings I hand a friend of petition because election into no so pleadings no me de bar onipa na me de assembly tian no ono so file the friend of answer but what has here answer no obehwe ni mienu in other instances no which make us so yenye the friend of directions directions no we are which make us you from this no yen file the friend of witness statements so witness statements and then they say over my witnesses are back courts abeka de omunim efasem no into utu sana monu ewia na fe witnesses na ba abegina witness boss normal take the oath na ya cross examine. Now in this case after the direction judge no kaso pleadings na ewon enim according to ono they are admitted facts into no ehia say obe call it for quote unquote witness statement na obeso on disposing of the matter with the friend of legal arguments into ye consider be an in because ye dream pan say their issues are a calling for evidence a ebe hia so obi ba begina adaka mu ama yatoto na no o se oni yen ya adwen nti etu anamon se sa decision no yebe den yebe appeal ma ye file appeal ekokoro
to that ruling
nti emra ekoba sa no ye court of appeal say almost stay proceedings for the time being nti edu court of appeal na court of appeal can say there amendment to the court of appeal rules and to say no yet me ma for stay of proceedings. But what you say?
Me too.
In Jacoba Sano, now as he go back to the High Court. 2. The friend is Sorara and Supreme Court. Supreme Court said that be on the issue of enforcement and interpretation. Can say and among two bia Sebio, my lord, they take here, while raising some constitutional issue on Nankasa say or interpret it. Into a Supreme Court intervening. Sebi, okayfm Yankasa, Emrami years an auto case. An issue of that came up. Emma Meko Supreme Court. Now, in the Zenato scenario, no, there's a court an enemy adwin by 4-1 decision. And now, set aside the ruling judge make at the High Court. Say, to me to refer the constitutional interpretation to themselves, so that instead of bringing an application, Ebema judge now refer the matter. No, said that they have the power to refer the matter to themselves. Their lawyer for can slow motu. It almost refer the constitutional interpretation matter to themselves. So Emrana Yeko Supreme Court no. Omo can say no. In this case, no, we should go and raise that issue of interpretation formally before the judge. And that was a day before. Bakwame. Inti okaya statement be club abontin say an opatututu no ye call the registry of the court here be filed by 8. Bakwame. As at 8 I do on a registry ni MBA. By the time on maybe a registry around 9, our lawyer for years on be file a process. Exactly 9, a judge now started kind of way. 2, because here can say we want a situation where evidence will be taken into Brakwame. Taba no make it orders here and file the friend legal argument. You can say no, we believe say that will be premature. Let witnesses come, let them be cross-examined, let there be evidence on record of certain materials. Then we can take it out from there. Into also into by the time Yebeko Court of Appeal, Supreme Court Yebebano. Now, my lord, I take more or less a decision. In fact, Okaya, he was supposed to have given his judgment on the 14th. And now, your man arguing about so you filed these processes our Court of Appeal. In the Court of Appeals, your Court of Appeal on Monday. In the Court Supreme Court, I think on Tuesday or Wednesday. Until the very day now you Court of Appeal, the next day nana or man ruling. Yefi Supreme Court, the next day nana or man ruling. Until now and your money be a bit strange to us. Until Osha, as far as legal arguments were concerned, Obrakwame, he never had the benefit of hearing legal arguments. It was quote-unquote one-sided. 2, it wasn't deliberate on our part, say, we will not file our legal arguments. We have indicated, say, we have filed appeal processes. And so, based on the ruling for us to file those, you're filing certiorari. The certiorari was determined, say, Tuesday. Wednesday, not on my decision. So the opportunity for us to even file that process, for him to even consider it in order to deliver a decision that will reflect both sides, no, and so. But no caso, once a judge, no, he has the power to proceed. Inti na the kind now notice of appeal and I'm not permitted to argue the appeal. Just to highlight the grounds, this ground, this. Inti you formulated several grounds of appeal. Inti the kind say, Oshe case we decided the case on the critical issue of the nomination period. Critical, the nomination period and the nomination date. Mama one who said, Miami Senior Gary Namakon, any ambassador you could, Omuye Dr. Parkwesin do case no. Emma Supreme Court through Justice Adina. Emma the scope of what the nomination date is and what the nomination period is. Because now the Electoral Commission in that case and they say Omama dates for filing of nomination. Na sa date na etwam no indum form no problem ewo ho. So on the basis of that, we disqualify them. But also kaisa issue no. Inti ekobasa no. Omo nullify ne registration no. Oko High Court. Emma High Court any need to much one. The Electoral Commission offer no the opportunity for hearing, among other things. Inti asem no ekoya ma the Electoral Commission on the High Court in Yaji into Supreme Court for Sissurara. Now, Hona Supreme Court, I can't say nomination period, no, is different from the nomination dates. Now, the period for nomination includes the time for amendments, alterations, maybe a person yes and your money na. And then the can say so who apply to this case now. Whereas Electoral Commission can say nomination date no a year 5th to 9th October no. After the 9th no, Electoral Commission accepted a petition from concerned youth of Assin North against no. Emma and so why isi nanka sansa draw krata man say ni na nkrofo ye kan wanu ye ne saying a man de nanu ye e de buy together with the certificate of renunciation into the na ye kan na ne say that period no say my lord have it na or adverting in mind to the Supreme Court kan e wo indumwa obehu say the 5th to 9th no was not the deciding factor per se, but the period within which Electoral Commission had the opportunity for him to respond to a petition that was filed against him. Indeed, said, if all of these things had come to the attention of my Lord, with the greatest respect to him, maybe a different conclusion, and here a different conclusion would have been reached. Indeed, notice of appeal, no, they are called to court. We are hoping, say, a date for the hearing within this vacation. Are you a lawyer for your legal vacation from now to October? So we are hoping, say, a date within this period, and then we can take it up from there.
Now, law, Mammy Musadia, we yabano, Adena, Moye appeal, one sound file stay of execution. Konya sa Electoral Commission
no, Brakwame, step by step. I would say your court win your dear friend procedure. But what I say?
I mean
your procedure without a notice of appeal. Won't me apply for stay?
And I mean, just a 1 year, you know. Move on to your soul.
That be enter in America into the process is not say, file your stay. First of all, as you invoke the jurisdiction of the Court of Appeal. They invoke the jurisdiction of the Court of Appeal, the notice of appeal.
Okay.
So, and then the first step, you must first file it.
Court also, I take a judicial notice of it. Okay.
Now, who apply for stay of execution, no one attach a copy to the affidavit. When this argument DNA, the other lawyer no be raise a preliminary legal objection say your application for stay of execution is incompetent, and that will end it. Step by step, you consider everything. So just wait and see what happens in the coming days.
Mami radio law ba kwa na wo kan say matter bia na a border on interpretation the apex court of the land, which is the Supreme Court no, and say ye dey call for interpretation. Aha no the trial judge na otena adwamu no wono no mo register o kan say. Okay,
so in your mind you see okay, there was an earlier application for injunction. But it's okay.
I'm a kaipa.
Good. At that application for injunction, you raised the issue, say, with the no, this one had to do with Article 94 2A. Now, that provision no receive any interpretation by a apex court. Because here I can say, citizenship is not the same as allegiance. Allegiance is different from that. And so, our contention, and they say, at the trial court, and they say, the moment in December 2019, Oman, the constituency chairman, a year attestation, or the kind of application who they command Canadian authorities. Our contention is that from that day, he disavowed his Canadian allegiance to Canada. And so the question of allegiance comes from the individual. Sebio, I say, one or swear. But what I say, I one swear. And you know, what the crowd are says, he say, my parliamentary candidate, my NDC. And you know, me know yatun kwanta yapai. From that time, no, yes, I admit say, only in terms of allegiance, no, only Canada abobra, sabi. Now, also your constitution now, where a user citizenship, a citizen, no, a user. Where a user allegiance and no, a user. In the air can say, if the framers of the Constitution intended, say, in Article 94 2A, no, allegiance should mean citizenship, they would have been clear in that provision. So to the extent that there's a challenge. No, can't say. That's during the injunction application. No. Oh, this matter has been decided in the Zenato matter. Yes, no. Zenato was Article 94(1)(1). EFA voter card and in nomination period. That is fundamentally different from 94 2A. If you best say no, on stay now on refer the matter. No, so once the provision you play, no, he can go ahead and deal with the matter, even at the injunction stage, and the ruling is there. What I say? The end I can say you best say no, Nanka, and in fact, also judgment, so he repeated the same claim. Say as far as he is concerned, the provision is clear, unambiguous. So an issue of interpretation does not arise. And so he can proceed to enforce the Constitution with the greatest respect. Intuition is one of our grounds of appeal.
Oh, okay.
It's one of our grounds of appeal. And yes, I raise it. The more fundamental issue say, as to what time a person should be qualified, there's what we call the Representation of the People's Law, PNDC Law 285, on parliamentary election. No say in section 20, or say a person should not be disqualified at the time of the election. At the time of the election.
At the time of the election.
Of the election. That is what the statute says. And it is clear, say, to Abano on
now, the PNDC law 285, no, is it not in contravention to Article 94 clause? No, that provision has been held by our courts to be valid. Oh, okay.
So, in most parliamentary election challenge, that provision has been used. That you should not be disqualified at the time of the election. The statute provides it. So, I can say with the greatest respect, if you are course now, who say, as at the time of the election, December 7th, no nomination, assuming even for the sake of argument, no certificate of renunciation on 26th of November. Yet to abandon so on the 7th day of December.
Actually, at the time of election, no, said PNDC law.
No one yet disqualified.
No one yet disqualified. And when you're 26th November. Okay.
So we are saying, with the greatest respect, if my Lord had considered the Article 94(2)(a) read together with sections 20 now, Obi said no, even on the admitted facts, no. The Honorable MP, no, could not have violated the provisions of our Constitution.
Okay.
So we have formulated the grounds of appeal, and we are hopeful that we'll receive a favorable outcome from the Apex court.
Now, Mami Musa says in appeal, no, and with the same court, and now say a appellate court.
For civil procedure rules, no, I would say we have civil procedure rule for the High Court, civil procedure rule for the Court of Appeal, and for the Supreme Court. For the Court of Appeal, no, and the High Court, no, or file an appeal emanating from a decision or an order of the High Court now, or file the notice of appeal at the registry of the court that delivered the judgment. So in this case, the notice of appeal is filed at the registry of the High Court. Then the High Court, no, the friend of settlements of records, the appeals record. Normal the form be a friend of Form 6 at the account. Normal transmitted at the command the registrar of the Court of Appeal. Then the matter proceeds. So you file it at the registry of the High Court. Or now file it at the registry of the Court of Appeal. The appeal will be deemed incompetent.
Okay. Papa, this saying as it stands, letter commission, no, what would they intend to organize by-elections?
I would say, first of all, the speaker would have to, through the clerk, would have to write to the electoral commission about the seats being vacant. I am not aware that has been done.
Okay.
So let's see how things pan out going forward.
Now,
Sebi, maybe it's a hypothetical scenario. When you pay a filing notice of appeal, now Assembly Court of Appeal ID, Court of Appeal ID and also High Court with this issue now would declare election on null and void. No, it's not proper. Ekobanes are Brakwame. Now Assin so quite ahead no koye election. Now ya elected candidate who will become the MP. Asem Sebe. Obina enjum to Obina or say Kuku Frimpon, what the Assemble?
Aye, Sajum, not then as I say, as I'm on your friend with days. Now, say, Brad, could you back of it?
OKFM 101.7.